For 26 years, a single Kenyan family waged a legal war over a piece of land barely larger than a football field. It was a fight that eventually forced the Supreme Court to address a specific procedural flaw in the justice system. The conflict started in 1998 with the death of Magu Mwenje. He left behind 1.33 acres of rich red soil in Kabare, along with 11 children and 2 widows. Anna was his statutory wife, legally married on paper. Jane was his inherited wife, recognized through local customary tradition. Both women had built their lives on this land, and both had raised his children here. Jane went to court demanding legal recognition as a legitimate heir. In response, Anna's son Elliot fought Jane at every stage, determined to protect his own mother's exclusive claim to the estate. 2 houses competing for limited resources. This scenario plays out in families across Kenya. Grieving children and widows frequently walk into courtrooms to fight these battles over land and legitimacy. Fast forward to 2015. After 17 years of lower court skirmishes, the High Court stepped in and ordered a compromise. The property would be divided equally between both widows' houses. Eliud rejected the compromise. He immediately filed an appeal to stop the surveyors from subdividing the estate. But when he reached the Court of Appeal, the judges refused to look at his evidence. They threw his entire case out. After 17 years of litigation, the case ended here. It stopped not because of a lack of proof, but because of a single missing procedural requirement. To understand how a case evaporates at the appellate level, we have to look at a specific legal mechanism known as leave. As this flowchart illustrates, leave is a formal request for permission. In certain scenarios, you cannot simply file an appeal. You have to formally ask the judge for the capacity to proceed. Elliot didn't ask for permission, so he was denied a hearing. From Elliot's perspective, this was a barrier to justice. He argued that the Kenyan Constitution guaranteed his right to be heard without needing a judge's prior approval. His frustration exposed a structural tension in the judiciary. Does a citizen have an automatic right to challenge a decision, or is an appeal a privilege granted at a judge's discretion? The source of the confusion lay in the Law of Succession Act. The act is silent on whether high court appeals require this concept of leave. This silence led to a split in the judiciary. Some judges demanded permission before an appeal could proceed, while others allowed them through automatically. Without a clear rule, families navigating inheritance disputes faced inconsistent outcomes depending on which legal interpretation a judge followed. Eliud took this unresolved question to Chief Justice Kume and the Supreme Court to get a definitive answer. The court compared how laws are structured. On the left, statutes explicitly requiring leave. On the right, the Succession Act contains no such instructions. The justices ruled that when a statute is silent, judges cannot invent restrictive hurdles not written in the text. The court based its decision on Article 27 of the Constitution, which guarantees the right to equal protection under the law. If a family starts a succession case in a smaller magistrate's court, the law grants them an automatic right to appeal. The court found that denying that same right to a family starting in the High Court creates an unconstitutional double standard. The precedent is now set. For everyone navigating succession disputes, the right to appeal is automatic. No prior permission is required. The ruling reached far beyond the Supreme Court, landing back in the red soil of Kabare. This decision established a single standard for succession files that had been delayed by this specific legal gap, offering a clear path forward for families in similar situations. As for Eliud, after 17 years of litigation and a long delay over a procedural requirement, his appeal is finally being sent back to the Court of Appeal to be heard on its merits. It took a decades-long family feud over a small patch of land to force the justice system to clarify a fundamental constitutional promise.